an independent CBI investigation to prevent miscarriage of justice. Additional Solicitor General Aishwarya Bhati Raju, appearing for the Enforcement Directorate, pressed the bench of Justices Prashant Kumar Mishra and Vipul M. Pancholi with a strong plea for direct intervention, stating on, "If I don't come here directly, then my fundamental right will be affected," arguing that the ED's investigative powers and the fundamental rights of its officers are at immediate risk, justifying the invocation of Article 32 jurisdiction in the Supreme Court rather than waiting for the Calcutta High Court. The bench, however, pushed back firmly on the need for parallel proceedings, responding, "Why can't you continue in the High Court post-lunch?" questioning why the matter cannot be pursued and resolved in the Calcutta High Court, where related proceedings under Article 226 are already underway, and directing the hearing to resume after the lunch recess. I have Senior Advocate Adish Agrawala, Supreme Court, joining me on the broadcast. I want to go across to Mr. Agrawala. Now, Mr. Agrawala, a lot of developments as far as this case is concerned. What would you like to say?
See, the allegation by Mamata Banerjee side counsel that it is a forum shopping, this is totally wrong. Because initially the ED filed petition in Calcutta High Court, but the other party, the parties of the government and the TMC leaders, they created a situation that judge could not hear it. And that's why there was no other option with the ED to approach the Honorable Supreme Court. And I'm saying without even approaching the High Court, they could have come directly also. So they can't allege. They have no authority to allege that is a forum shopping. And rightly, the Honorable Supreme Court is hearing, because there the situation is not proper. The workers are not permitting the court to function to hear this case. So now it is to be seen whether the court is asking the CBI to investigate the matter, because where such thing have been done by the senior police officers and the chief minister, maybe a party leader. So local police is not going to register the case of this matter of manhandling and taking away the documents which were seized by the ED. So now let us wait. Things will be clear, and I hope that the Honorable Supreme Court will allow this writ petition, and they will hear at length, and they will pass appropriate order of giving this investigation to CBI so that proper investigation can be done. Otherwise, local police, even if a case is registered on the instructions of Supreme Court with the West Bengal police will be not properly investigate the matter, because the senior police officers are involved, the chief minister and party president is involved.
All right, Mr. Agarwal. Now, of course, I want to also go across to Advocate Jasmine Damkiwala, who is an advocate at the Supreme Court. Now, Advocate Damkiwala, how do you feel about the latest developments in this case?
See, essentially, there were two things I wanted to point out. First and foremost, parallel proceedings cannot run in the same prayers. That is basically the whole aspect of committee of courts. There are basic, part of the basic structure of the way the judiciary functions, that you can't have parallel proceedings in two courts on the same prayers hoping to succeed in one of them. That's one. Second thing I wanted to point out is that Article 32 cannot be filed when there are disputed questions of fact. Now, from what we've been hearing on news reports yesterday and today, I have not watched the proceedings, but I've been following the news. What we see is there was a premise that TMC officials broke in, snatched away, took away, mishandled people, took away the phone, took away papers. And from that point, and that is what was reported, from that point where we start, we believe what is reported. The common man, as lawyers, we can still watch judicial proceedings, but common man believes what he sees. So, given that premise, you feel that, okay, the fact is established that there was taking away of material and everything, and then 32 can be invocable. But from what the submissions we heard of Mr. Kapil and Dr. A.M. Singhvi, which I am following now, apparently the whole fact of what happened there is itself disputed. So the disputed question, here again I'm making 2 points. One, Dr. Singhvi and Mr. Kapil are absolutely accurate when they say there are disputed questions, and disputed questions of fact cannot be raised in Article 32 petition. Second, I would most humbly say that media also has to be a little careful while reporting, because we are reporting based on premise that, okay, this incident happened, instead of there is an allegation of. So the common man believes that this incident happened. So there we have to be a little careful, because it has been happening not just in this, but otherwise widely, not just this channel, but throughout, that there is something taken as a premise. Like that's the same problem in the street dog matter. There is a premise of a bite, when the whole very issue is disputed. So that is where I'm saying that we need to take allegations as allegations and not as facts, and start from that point. And when you examine from that point, then there are vital constitutional issues of whether 32 is invocable or 32 is not invocable, whether 226 should have been followed and pursued, or whether that should have been withdrawn and here it should have been pursued. So those things have to be taken into consideration. If there are issues pertaining to law and order during proceedings conducted before the Honorable High Court, then the High Court has enough powers to even issue orders to in-camera proceedings for sensitive matters. So there are recourses. But we'll have to examine the constitutional aspect and whether 32 is even maintainable before this. Second, what Dr. Singhvi is saying is that don't issue notice in the matter. You hear the matter at name before issuing notice. Because once notice is issued, then the Honorable Supreme Court has been taking position cognizance of the petition, and there is a presumption that the petition is at least underway. Notice is issued. But on the question of maintainability or in the alternative, notice can be issued on the question of maintainability. So then maintainability can be examined, and if it is maintainable, then it can be proceeded with. That is what I wanted to say. These are the pure legal aspects I wanted to point.
All right, Ms. Amkewala, thank you so much for joining me.